Welcome back to our MiCA at a Glance video series. It's great to see that you are following our journey into the depths of crypto regulation in the European Union.
Hello everyone, it's good to be back.
So, in this video, we'll describe the general areas of MiCA regulations application, focusing on the different kinds of crypto assets that it identifies and affects. Tavi, can you please start the provision of a short overview of the crypto assets MiCA applies to?
Of course. So in very broad terms, the regulation applies to all crypto assets. That's including NFTs, utility tokens, stablecoins, you name it. By definition, anything that is a digital representation of a value or a right that is able to be transferred and stored electronically using DLT or similar technology can be considered to be a crypto asset. However, some crypto assets are exempted, while others are subject to certain exceptions.
And one thing that I'd like to mention here is that in the EU, we use the term crypto assets instead of virtual assets. So just to be clear, when we'll be referring to crypto assets, they are going to mean the same thing as virtual assets.
That's right. And throughout the mini-series, we'll also be referring to CASPs instead of VASPs.
All right. And now back to the definition. Let's find out whether it is all-encompassing definition where no crypto asset sits on its edge, because the definition identifies several conditions for something to be considered as a crypto asset. Basically raises four main conditions for something to be called a crypto asset. First, it has to be a digital representation. That means non-tangible, even though it can refer to a tangible item. That's why there is a word representation included. Then, secondly, the representation must be of a value or a right. So again, that digital representation has to grant something to the holder. Then the third point is that the representation of a value or a right must have the ability of being transferred and stored electronically. And the fourth point, the transfer and storage of that digital representation of a value or a right needs to use electronic DLT or similar technology. So it's not either or transferred and stored, but the representation of value must have an ability to be transferred and stored electronically.
That's right. And actually, this wording makes a huge difference because some crypto assets may not be transferable. Likewise, I would like to add one more thing, that DLT should be understood to include all forms of blockchain. So that's directed acyclic graphs, hash graphs, holochain, tempo, and any other form of DLT that might crop up over time. But as you said, in essence, we have four conditions for a crypto asset. It has to be digital representation, there has to be value or right, transferable and storable, and it must use DLT.
Sounds simple enough. However, as usually in a law, there are things that may fall outside of their definitions. Do you, Tavi, know any crypto assets that could potentially be outside of the crypto asset definition under MiCA?
Well, that's a great observation. And frankly, there's one form of NFT that pops to my mind that checks all of the boxes, except for one, which is its transferability. So there's a type of NFT called the soul-bound token, which is an entity-unique NFT that is attributable to a specific person or entity, for example, a university diploma or a license. So this means that while I could transfer a digital art NFT, I wouldn't be able to transfer my university diploma to someone else, nor could an electronic money institution transfer its license to another company.
Interesting. And even though the definition sounds simple enough, apparently there is a lot to consider when defining what a crypto asset, and only after correct classification it is possible to go to the next step to clarify what requirements of MiCA regulation to apply to them and to what extent.
That's right. And this means that there's definitely a need to understand the scope of the regulation so that a company can be certain whether its activities are regulated or not.
Great. Now that we understand the definition, it is time to discuss the types of crypto assets it encompasses so that we could have a better picture of the regulation boundaries.
Right. So in very basic terms, the MiCA regulation categorizes crypto assets into two principal groups. These are stablecoins and non-stable coins. Stablecoins are crypto assets that maintain a stable one-to-one value in reference to a fiat currency. So an example of a stablecoin would be Tether's USDT or Circle's USDC coins. Then MiCA identifies two kinds of stablecoins. There are asset reference tokens, or ARTs for short, and e-money tokens, or EMTs for short. So the difference between them is the entities that are allowed to issue them and the assets that can be used to maintain their stable value. Now, in terms of non-stable coins, these are all other crypto assets within the regulation's definition that may not even be coins or tokens whose price may fluctuate based on their demand, or those that are used for a very specific utility. And quite honestly, the list goes on and on. So some examples could be Binance's BNB coin, Solana's Sol token, but it could also be just as easily Cyberpunk's NFTs, proof of attendance protocols, or POAPs. And you name it. So as we've discussed, if it's a legal representation of a value or right that's transferable and storable, and it uses DLT, there is a good chance that it's a crypto asset.
And here it would be good to explain to our listeners that definition and examples of crypto assets exemptions, which may be applicable to some specific crypto assets and might ease the life of some of the businesses. Let's dive into that process a little bit more, Tavi.
Of course. Now, in terms of crypto asset exemptions and exceptions, in a very general sense, they either apply based on their value, their effect on the financial market, their intended holders, or they're generally exempted due to their inherent nature, like financial instruments, deposit securitization positions, etc. In order to know what exemptions and exceptions apply, the first step is to determine whether it's a stablecoin or a non-stable coin, and then classify the crypto asset to a specific group, for example, stablecoin ART, non-stable coin utility token, etc. Once that classification is done, then the appropriate exemptions or exceptions can be identified.
All right. I think we need to be a little bit more specific about the exemptions applicable non-stable coins.
Sure. So firstly, just to be more specific and clear to our audience, I'll recap. So the class of non-stable coins includes such crypto assets like NFTs, utility tokens, and other non-descriptive crypto assets like Ripple's XRP, Cardano's ADA, Dogecoin, Bored Ape Yacht Club NFTs, etc. In terms of NFTs, for example, they are completely exempted from the regulation, but it's only under one condition, that the NFT is truly unique and non-fungible, because the regulation identifies that fractionalized parts of a unique NFT should not count as unique NFTs. Fungibility, for those that are not aware, in this context means that the item is replaceable with another equivalent item with the same value.
So, for example, the euro would be fungible because we could replace one 100 euro bill with any other 100 euro bill without any detriment to the holder.
That's right. And on the other hand, a non-fungible token or an NFT could not be replaced even if it represented the same asset class. So, for example, an NFT ticket to the theater with a seat number would be a unique NFT, even if it costs the same as the other tickets. But the fact that the person was able to choose his preferred spot in the theater, that specific seat is not fungible.
Yes, like a theater seat in the balcony is not fungible with a seat in the mezzanine.
Exactly.
So what about fractionalized NFTs? Would they pass as unique NFTs?
That's an excellent observation. And in terms of fractionalized NFTs, even though the regulations preamble states that fractionalized parts of an NFT shouldn't be considered as unique NFTs, this, at least in my opinion, would need to be detailed by further regulatory standards. Because let's say we mint an NFT of, let's say, Mona Lisa's painting. Now, the painting would have a uniquely identifiable digital version of the painting. When the fractionalize that NFT into, let's say, 100 NFTs, according to the regulations preamble, those fractionalized parts shouldn't be considered as unique NFTs because they're simply not unique enough.
But what happens if those NFT fractions represent unique pieces of a Mona Lisa's image?
Well, that's a different story, and that's exactly my point. I'm certain that fractionalized NFTs of the Mona Lisa's painting would have unique collectible value if they had specific pieces of a painting attached to those fractions, because obviously someone would like to have Mona Lisa's smile.
So the main message here is that even though NFTs are generally exempted, companies should nonetheless legally evaluate their assets and activities just to be sure that they are exempted. In addition, usually NFTs minting is only part of the overall activities of a company, but CASP services are a separate discussion altogether, and we will discuss it in another episode. In summary, we could say that NFTs have a separate class of exemption criteria, and based on the amount of different kinds of NFTs that are out there, all exemptions relating to NFT activities should be considered on a case-by-case basis. In addition to NFTs, there are other types of non-stable coins and legal rules of exemptions.
Correct. And in a very broad sense, crypto assets that are not intended to be admitted to trading on a trading platform and whose overall aggregate value is below 1 million euros is largely subject to some sort of exception. So the first thing to note here is that simply issuing crypto assets is unrestricted in any way. What is regulated is the crypto assets offered to the public or their admission to trading. In very simple terms, an offer to the public is when a crypto asset issuer basically offers the crypto assets for sale by its own means. Whereas the admission to trading is when a crypto asset is listed on a trading platform. So if the crypto assets are neither offered to the public nor admitted to trading, then their issuance is exempted. Now, utility tokens, for example, are completely exempted as well, though the catch here is to have some solid reasoning on why that crypto asset should be considered a utility token, especially if it's listed on a trading platform. Now, other exemptions relate to some offers to the public where the issuer shouldn't need to prepare the white paper in their marketing materials. So these exemptions apply only in some limited circumstances, like if the issued crypto assets offer value is below 1 million euros, the offer is available only to qualified investors, or a very limited number of investors in each member state. Some further exemptions apply to crypto assets that are offered for free, or if they are automatically created as a reward for the maintenance of the DLT.
I would like to jump in and explain to our audience that this is exactly what applies to Bitcoin. Bitcoin does not have to be issued by a legal entity, nor should its white paper adhere to MiCA's requirements, because Bitcoin is created as a reward. Bitcoin was also fairly launched, which means that all Bitcoins were mined, and this is important because some mineable and stakeable coins may be created as a reward similarly as Bitcoin. But before they were offered to the public or admitted to trading, they were pre-mined. So there is a chance that they would not be exempted from the requirements to be issued by a legal entity. So this exemption would again need to be evaluated on a case-by-case basis.
That's exactly right. And that's why it's important for companies to be careful with attributing the exemptions by themselves, because something that may appear really straightforward might actually be quite nuanced. And the final group of crypto assets that are exempted are the ones that can be used in a very limited environment. So these are like loyalty points and similar items.
So what we try to explain here, there are a lot of different types of non-stable coin crypto assets that might be exempted under certain conditions. However, the exemptions are rather sophisticated, which suggests that to be certain, each crypto asset needs to be assessed individually, because at first glance, they might appear as exempted, but under closer inspection, they could be subject to the regulation. For instance, the crypto assets that are created as a reward but have been pre-mined. This regulation compels crypto markets participants to assess their activities and decisively classify their crypto assets so that there is no ambiguity for regulators, businesses, or most importantly, to the consumers. And now we will discuss the exemptions for the stablecoins.
Okay, so jumping into stablecoins. In terms of stablecoins, the exemptions are quite narrow compared to non-stable coins. So let's say ART issuers, for example, may be accepted from the authorization process if the token's value does not exceed 5 million euros, or if the tokens are offered only to qualified investors. So this could be a great solution for some specific business models. And now in terms of e-money tokens, well, there are some limited exceptions to their issuance, but they really depend on the regulator and as is prescribed by a 2009 directive on the supervision of electronic money institutions.
Well, we are happy that we had discussion because it's obvious that the MiCA regulation is so diverse that even a discussion regarding its exemptions is a topic of its own. That's why it is important for every crypto market participant to really thoroughly evaluate their activities to be sure that they stay compliant once the MiCA regulation is fully implemented.
We also know that this was definitely a very complicated topic and probably hard to follow, but we are grateful for your attention nonetheless. We extend our heartfelt gratitude to each and every one of you. We're very thankful for all your support after our previous episode, your enthusiastic participation in our MiCA at a Glance mini-series, and obviously the questions that we received are the best motivation for us to keep exploring this topic in more detail so that we could bring you the topics that are most important to you and your business.
As we conclude this episode, we want to express our appreciation for your time, interest, and invaluable contributions. Thank you for making MiCA at a Glance a resounding success, and we look forward to continuing this journey of discovery together. And please contact us for more information and free initial advice on MiCA licensing.